We are about to begin our last session of the day very shortly. Please make your way to the table and take your seats now. Thank you.
I believe last but not least is the right expression here. Session 3 deals with the exhaustion of IP rights. The moderator of Session 3 is Honorable Presiding Judge Kyuhong Lee of the Patent Court of Korea. Please join me in welcoming him.
Good afternoon, ladies and gentlemen, honorable speakers and distinguished guests. I am Kyuhong Lee, currently presiding judge of Patent Court of Korea. I am very glad to have opportunity to be a moderator of this great session. And as you know, we have already discussed two interesting topics, two big topics today. And I know that this is a time most people get a little bit tired. But I hope, because we will discuss various practical topics at this session and get valuable opinions and implications from the prestigious global patent experts. So I hope you enjoy this session. And this is the last session. Before starting this session, I would like to introduce our honored speakers briefly. We have 5 honorable judges and 2 distinguished lawyers from all over the world. I will present one by one from my side. If you would like to know more about them, their full biographies are in the materials. Please give them a big round of applause. To my next is the Honorable Judge William ALSUP. As introduced in session 1, he is a judge of U.S. District Court for the Northern District of California. Second, the lawyer Yinji Fang. As also introduced in session 1, she is from China and has been working at the LIFANG and Partners Law Firm in China. Next is the Honorable Judge Jeong. She currently works at Patent Court from this year, but prior to being a judge, she worked as a patent attorney with several patent law firms. From 1997, she held a bachelor's degree of biochemistry from Yonsei University. Next, the speaker is attorney Jeong. Attorney Jeong is a partner at YULCHON's Intellectual Property Division with extensive experience in a wide spectrum of matters, including some of the largest patent and SCP-related antitrust cases in Korea, trade secret cases. Attorney Jeong joined YULCHON in 2012, bringing with him the 14 years of experience serving as a patent examiner at Korean Intellectual Property Office. The next is the Honorable Judge, Dr. Oliver SCHÖN. As also introduced in session 1, he is a judge of the District Court of Munich, first, Germany. And next, the speaker is Honorable Judge Toshihiko TSURUOKA. As also introduced in session 1, he is a presiding judge of Intellectual Property High Court of Japan. And the last speaker is Honorable Judge Jiyoung. She currently works at Patent Court from 2018. She got her bachelor's degree, a master's degree of pharmacy, and completed her PhD course of pharmacy in Busan National University. And she also got her bachelor degree, another bachelor degree of law, and completed the master course of law in Seoul National University. She studied at George Washington University as a visiting scholar. Well, yeah. And the general notification, the session 3 is about best topics, as you know. So before we start, I'd like to especially ask the speakers to keep your time limit. Each one of you will have basically just 2 minutes. I'm so sorry, but just 2 minutes for the presentation. We need to finish our session by 6 p.m. for our delicious dinner is awaiting us. In honesty, let's move on to the topic, exhaustion of rights. We sent several questions to the panels in advance about the topics of today and got answers. Then we have made a PowerPoint file. It will show the summary of our panel answers. This is the front page. And the concept of exhaustion of rights, unique in IP, has been discussed theoretically and practically with the development of IPR system, especially in modern society. With the development of science and technology, the scope of IP rights has been expanded widely and lawful. Furthermore, fair exercise of IP rights has also added importance. However, the doctrine of exhaustion is not always regulated by the written law or treaties. So there are still differences according to the situation of each country. Therefore, it would be necessary to discuss the differences in each scope of patents, trademarks, designs, copyrights, and to discuss the domestic exhaustion and international exhaustion for the purpose of fair development and the desirable future of our IP system. We will discuss with experts from different countries for that goal. 5 subtopics: exhaustion of rights in general, and contract and exhaustion, repair and exhaustion, process invention and exhaustion, finally, parallel import and exhaustion. Let's start topic 1. Topic 1 is about exhaustion of rights in general. The doctrine of exhaustion is discussed beyond the patent concerning all IP rights such as trademark and copyrights. Many countries have recognized this doctrine in the form of statutes, legal doctrines, or cases. According to the slide number 1, each country has its own ground for each IP right. The question to the panels in advance is like this: does your country or court recognize exhaustion of IP rights? If so, please cite specific laws or doctrines or cases. As you see, each speaker answered like this: statutory or doctrine. So this question is directed to all speakers. Judge ALSUP, would you be the first speaker to answer this question?
It's late in the day, so this is a good time to talk about the doctrine of exhaustion. That was Judge Stark's thought. Okay, thank you. Yes, USA, doctrine of exhaustion, yes. In the patent context, for example, what that means is that when you have a patent, you have the right to exclude others from making, using, selling, offering to sell the patented, let's say, good. So no one else can do it, but you can do it, or your licensees can sell. However, once you sell the good to somebody else, there are no more patent rights, none. That product now belongs to the consumer, and they have the right to do with it whatever they want. The U.S. Supreme Court had a landmark case 2 years ago on that very point. It's the Lexmark Case, and it held that both sales in the USA, exhaustion, and if you sell overseas and then it comes back into the USA, exhaustion there too. So that's the rule in the United States. There is the doctrine of exhaustion, and it's pretty strong in favor of the consumer and against the patent holder.
Yeah, thank you for your detailed answer. What is the opinion on this question, the Judge SCHÖN?
Thank you very much. In Germany, there's a little bit different approach. We also have the principle Doctrine of Exhaustion, but it's limited to the European free trade area. So maybe German law is not so consumer friendly. The reason is basically that the IP law have a territorial base, but inside the European Union we also want to give a free trade. So like what we see now, it's a compromise, and so it means if a product is given into the market by the right holder or in consent with the right holder cannot limit the circulation within the European free trade area, but there's no international exhaustion. So if it's distributed in a market outside EFTA, it can infringe patent rights or any other rights.
Yeah, thank you. What are your thoughts on this, the attorney, Fang?
Thank you for the question. In China, with regarding the exhaustion of patent rights, Article 69, first paragraph of the Chinese patent law states that the acts of using, offering for sale, selling, or importing of any patented product or product directly obtained under the patented process after the product is sold by the patentee or by its licensed entity or individual should not be deemed as an infringement of the patent. The exhaustion of patent rights will only be established if the patent products that are used, offered for sale, sold, or imported are purchased from the patentees or their licensees. Such purchase need to be proven by the defendant through the evidence. Let me introduce a case. In a patent infringement case, the defendant claimed that alleged infringing product came from the plaintiff and submitted a WeChat record, order and payment voucher, delivery note, and the supply statistics. The court combined evidence and the plaintiff's statement in the court to determine that defendant's defense of exhaustion of patent right was established. The defendant's offering for sale or selling the product is not considered to infringe the patent and does not bear the liability for infringement damages. This is a patent case. Next is a trademark case. Regarding the trademark, the Chinese trademark law has no explicit provisions regarding the exhaustion of rights. In a case where the exhaustion defense supported by the courts, the reason for the allowing the exhaustion defense was that a third party's release of goods bearing the registered trademark in issue, which were legally sold within the territory where the trademark was registered and has not been changed either in appearance or quality, did not infringe a trademark. Next is copyright case. Regarding the copyright, the Chinese copyright law does not expressly provide any provisions for the exhaustion of copyright. Currently, the courts in China have recognized and adopted the doctrine of distribution right exhaustion, which, however, is also derived and concluded from the interpretation of the relevant cases. Let me introduce a very famous case. It's a computer software case. The court held that once the replicas of computer software are lawfully distributed, the owner of the replicas may transfer the software for redistribution, and the copyright holder shall have no right to stop redistribution. That is, in terms of the replicas of software that are lawfully distributed, the copyright holder has exhausted its distribution right. So, in conclusion, the courts in China will generally consider three factors when applying the doctrine of copyright exhaustion. First, whether the works have been distributed once. Second, whether the alleged infringer has a lawful source or authorization in terms of the alleged infringing products. Third, whether the alleged infringement has overstepped the scope of lawful authorization. Thank you.
Yes, thank you. Thank you for your detailed answers. And it's very interesting. China has the statutory ground about patent law. Yeah, it's very interesting. And what's your opinion on this Japan Judge Tsuruoka?
Thank you for the question. In Japan, as for the Copyright Act regulates the exhaustion of transfer rights, including international exhaustion. As for the patent rights and trademark rights, there are no legal provisions. But domestic exhaustion is affirmed by the Supreme Court decisions, and the requirement of the exhaustion is legal transfer of the product. On the other hand, international exhaustion is denied by the Supreme Court decisions. But even if the product is transferred in a foreign country, the exercise of rights in Japan is restricted under certain conditions. Since the specific conditions will be asked in later questions, I will omit that discussion here. Thank you.
Yeah, thank you. And lastly, what about Korea, Judge Lee?
Yeah, I really appreciate to participate in this conference. In Korea, patent and trademark right exhaustion are based on theory and legal precedents. In contrast, copyright exhaustion is on statutes. There are two additional laws that regulate exhaustion about semiconductor and plants. In order for patent exhaustion to apply, 4 requirements must be met. The first requirement is that the product which is sold must be based on patent invention, and the product sold must satisfy all components of patent claims. However, if only part of components are embodied in product, or in the case of process inventions, then exhaustion will be applied under certain conditions. We will discuss about it in question 3 and 4. The second requirement is domestic sale. When a patent product is sold in overseas, there are many legal theories about patent exhaustion, but generally, exhaustion is in principle applies to domestic sale. The third requirement is that it must be lawfully based on patentee's intention. In other words, the patent product should be sold within the scope of authority. This is based on policy considerations, which said that patent will not be admitted beyond authority. Because there was a product sale based on patentee's intention, and a patentee received a fair gain. But regarding the case where a licensee or a buyer treated the product beyond authority, for example, newly manufacturing, there are many different opinions about it. So we will discuss later in question 2. The fourth requirement is that on unconditional sale. The patent exhaustion is a legal principle that applies when there was unconditional sale of the product. However, there are different legal views all surrounding this topic, so we will discuss about this topic in question 2. That's it. Thank you so much.
Yes, thank you. Thank you, your answer. And I think we can confirm the difference between each country. Yes, move on to next topic. Next topic is contract and exhaustion. Usually, patent holders usually try to maximize gains from their inventions by adding specific terms and conditions to sales or license agreements. However, those added terms and conditions often clash with the general principles of the transaction, antitrust laws, or fair trade regulations. And in result, whether to infringe the doctrine of exhaustion matters. The question to the panels in advance is like this. In your country, are patent holders and the purchasers of the patented product allowed to include provisions that prevent exhaustion in the purchase agreement? And is exhaustion recognized only when an agreement does not have such provisions? To this question, I want to listen the answers from the United States, Germany, and China speakers. Would you give us your opinion, Judge SCHÖN?
Thank you. So it is generally not possible to limit exhaustion except for the cases that are mentioned in Section 15 of the German Patent Act. You can limit exhaustion like on numbers and, for example, distribution area under certain circumstances, but except that it's not possible to limit. What's possible that the purchaser get a contractual obligation not to sell further, but if the purchaser would sell it anyway, it would not give a right to use patent right or trademark right or copyright in order to start an infringement case. And of course, when it comes to the contractual limitations, you always have to consider antitrust law.
Yes, thank you. Thank you, your opinion. And what is your opinion on this issue, Judge ALSUP?
In the United States, a patent holder may, by contract, impose conditions on the purchaser, but not under the Patent Act. So whatever restrictions that the patent holder wishes to impose cannot be anchored in the Patent Act. There are no patent, under the exhaustion doctrine, there's no way to sue for patent infringement. However, the Supreme Court in the Lexmark case specifically said, I'll quote, whatever rights Lexmark retained are a matter of the contracts with its purchasers, comma, not the patent law. So let's pause on that for a moment. The contracts might restrict resale, for example, or limit it to certain geographic areas, and that would be a matter of contract, but it could not be something you could sue on under the patent law. And it would not then, the patent holder could not sue the next step in the distribution process. If the purchaser happened to resell it anyway, there would be no contract with that downstream purchaser. So that right is pretty limited. So I'm distinguishing between the patent rights, those are exhausted, and the contract rights, those are not exhausted, but they only apply to the next level, the purchaser. Now, this is also very important, the same comment that was just made, antitrust laws. Antitrust laws and these contracts with the purchaser might, in the USA, violate our antitrust laws and lead to treble damages, 3 times damages, big time damages. That's something that the patent holder ought to think carefully about before they use the contract law to impose restrictions on resale. So that's the rule in the USA.
Yes, thank you. Thank you very much. Yes. And is preventing exhaustion by contract possible in China? Yeah.
In China, we are unaware of cases in point currently. In our point, the point is that exhaustion as a natural consequence of a first sale is the prevailing doctrine in China. The reasons are that, first, the exhaustion of patent rights is a statutory defense to infringement. Even if a patentee has restricted a purchaser's right to subsequently use, sell, and offer to sell the patented products, and that purchase violates those restrictions, that purchaser can still use the doctrine of patent exhaustion as a defense to infringement. Second, even if the exhaustion of patent rights can be excluded by agreement, such contractual provisions will probably be deemed invalid. Thank you.
Yes, thank you. Next, 2000. Oh my God. Yeah, next topic is next question is more practical and concrete, I think. So, in case where a patent holder clearly indicated on the product or its packaging that the product is for single use only, and the purchaser was aware of the fact at the time of the purchase, but resells the product as recycled from the original product anyway, is the patent right deemed exhausted? It's the very practical the question, and I want to get an answer from the Germany and Korea and Japan speakers. What do you think about this topic, the Judge TSURUOKA?
Thank you. Even if the label single use only is displayed on the patented product, the exhaustion of the patent right cannot be denied. However, if a patented product is replaced in parts or processed, and as a result, it is found that a new patented product that is not identical to the original product is produced, the conclusion is different. In this case, the patent rights are allowed to be exercised on the grounds that there has been a new patent infringement due to the manufacture of a new patented product. There is a Supreme Court case that made such a decision. Thank you.
Thank you. And in Korea, the answer is the yes or no. What it means, the Attorney Jeong?
Thank you. My view is that single-use only restrictions cannot prevent patent exhaustion. Authorized sale by a patentee or the licensee will automatically trigger the patent exhaustion, even with single-use only restrictions. The violation of such restrictions will be dealt under contract law. With regard to the precedents, there seems to be no Korean precedents on point. However, in Trademark Case regarding single-use disposable camera, the Supreme Court stated that processing or repair a product to the extent that would harm the identity of original product constitutes a prohibited reconstruction, and the trademark is not exhausted. But in that case, the word single-use only, it was not clearly indicated on the camera, but the purchaser's may have known that it was intended to be single-use from the limited numbers of shootings and the indicated in the package and the characteristics of the product itself. But I believe the Supreme Court case above is more related to permissible repair or impermissible reconstruction issues, which will be later in this session, rather than the single-use only restrictions. Thank you.
Yeah, thank you. What is your opinion on this question, Judge SCHÖN?
So the word single-use only cannot limit exhaustion, but we do have many cases where we have to decide if exhaustion is applicable or not. Normally, if a product is recycled, we look at it and decide if we consider it a repair or a new production. So, for example, like printer, toner, cartridge cases are very often happening. So we would say this is a new production, so it would not, it would fall under patent infringement. A recent case of the German Federal Supreme Court was the question how to handle a case when there's no consumer understanding because the product is not on sale. In this case, like a drum unit in a printer was replaced, and so normally there's no market for drum units. And in this case, the court said you have to look if the feature that shows a technical invention are changed, and if they are changed, it would be considered a new production and a patent infringement. If the other parts would be replaced, it may consider to be okay.
Yes, thank you. Thank you. And this means this topic is still very controversial, I think. So I expect related to the future, the Supreme Court cases in each country. And the next, the slide, as you can see, we made a slide about conflict with antitrust law and restriction on resale price. And this slide shows the emerging issue all around the world, conflict with antitrust law, and this issue is a very biased issue. And another hypothetical case, the restriction on resale price problem, and I think you may skip the details because of time limits and the volume of this topic. So, but the two topics must be a hot issue in near future in both IP law area and antitrust law area, I think. Please consult the reference book in detail if necessary. Next is the hypothetical case and the tying condition problem. Suppose that a patent holder granted the license for his or her patented product. This is product A, with the condition that demands the use of his or her another product, product B, as consumables for product A. That is so-called tying arrangement. And the licensee breached the condition and purchased product C from a third party to be used as a consumable for product A, as a breach of tying condition. The question is, in your country, does such a condition validly prevent patent exhaustion? And will the hypothetical licensee be found liable for patent infringement? This question is the Korea and Japan speakers. What do you think about this question, the attorney, Jeong?
Yes. My personal view is that the patents will be exhausted regardless of the tying arrangements. Again, there seems to be no Korean precedent directly addressing this issue, but KFTC's guidelines on the exercise of IP rights seem to be consistent with my view. Specifically, the guidelines state that normally when the patentee or the licensee sells an item, the patents can be considered as being exhausted. When the patentee imposes restrictions in the area where the patents are exhausted, or imposes restrictions unrelated to the patent, such act of imposing restrictions can be considered to be falling outside the scope of the patent monopoly. And as a separate matter, the invalidity or unenforceability of a tying clause would be examined by a separate analysis of whether those clauses are unconscionable or not under the civil law section 103 or 104. Thank you.
Yes, thank you. And Japan, the Judge TSURUOKA, the Japan has a related sentence about that.
Thank you. A related case is the Osaka High Court decision of 2003. In this case, the plaintiff had a patent on separation device and method for separating connected seedling pots. The plaintiff licensed the patent right to the defendant for use only. The license agreement provided that the defendant must not use the separation device to separate the connected seedling pots made by anyone other than the plaintiff. However, the defendant used the separation device to separate connected seedling pots manufactured by third parties. The plaintiff filed a patent infringement lawsuit against the defendant. The court said that the defendant's act did not constitute a patent infringement for the following reasons. The patentee can limit the scope of the license in the license agreement. In this case, an act outside the scope of the license in an infringement of the patent right. And restriction on the scope of the license include time, location, and content restrictions. But merely define the incidental conditions of the contract, and breach of incidental condition is merely a default, not a patent infringement. Continue. The condition that the separation device must not be used to separate third-party seedling pot is only an incidental condition of the license agreement. Therefore, violating this condition does not constitute a patent infringement. According to this judgment, the agreement of the tying condition seems to be only an incidental condition of the license agreement. Therefore, the violation does not constitute a patent infringement. Thank you.
Thank you. Yeah, very interesting case. I hope you can study and discuss more about the case. And yeah, next the topic is restriction of sales territorial condition. As you know, in case where a patent holder entered into multiple license agreements with multiple licensees that include restrictions of sales territories. For example, license A is allowed to sell the products only in territory X, and the licensee B is allowed to sell the products only in territory Y. And one of the licensees sells the patented product in breach of the condition. In your opinion, does the condition validly exclude exhaustion, or is the condition invalid and the patent is exhausted by the first sale? It's very concrete and practical problem, and I want to get some answer from Germany and Korea. What do you think about this question, Judge Lee?
Yeah. there's no relevant cases about this topic. In my personal opinion, restrictions on the sales territory may be possible if only license contract itself is valid, just like killer case of United States. Even if the product transferred, patent right itself isn't assigned or disappeared, but exercise of patent right is only restricted for policy considerations, such as safety of transaction or ban of dual gain. So, contract conditions should be given priority under the freedom of contract doctrine. If the contract with restrictions on sales territory is valid and the patent product is sold in violation of the contract, the patent exhaustion will be prevented and the licensee is liable for infringement. But when the licensee sells a product as conditions, the patent right is already exhausted with the licensee's rightful sale. So, even if the buyer knows this condition but uses the patent product as business against the conditions, the patentee cannot argue infringement against the buyer. If only there are the other contract between the licensee and the buyer, the licensee may argue contractual liability. But because there's no contract between the patentee and the buyer, contractual liability is impossible. It's my personal opinion. Thank you so much.
Yeah, thank you. And what is your opinion on this topic, Judge SCHÖN?
Thank you very much. So in Germany, it's possible to limit on certain sales territories. Section 15 of the German Patent Act allows to have licenses limited to some areas. And as I said before, exhaustion only always requests that the product has left the right holder's factory with his consent. So since he can limit his consent to some areas, it means that there's no exhaustion if the licensee A sells this in the area of license B. So it means that the right holder can start a patent infringement act.
Yes, thank you. Yeah, and the next question is very similar question, and that's because the sales venue problem. It's the required product to be sold only at a certain venue. For example, excluding online marketplaces. If some very expensive products are not, you cannot buy such goods from the online market. So some patent holder make the restriction to not to sell my product in online market. At the case, is it valid or not? So I want to get answer from the Judge ALSUP, because as you know, the Amazon and eBay or so many online vendors are in the United States.
Thank you. The answer in the USA, I'm pretty sure, is that the patent exhaustion rule would apply and that the patent laws themselves cannot be used to prevent an online sale. Now, the contract laws might be available. That would be a matter of state law in the United States and would get into an area called restraints on alienation that vary from state to state. It would also possibly impact the suspect under the antitrust laws, as I mentioned earlier. But the patent laws themselves could not be used to stop the resale of that product over the internet.
Yes, yeah, thank you for answer. And let's wrap up topic 2 because of time limits, and we are going to move on next topic. This topic is the repair and exhaustion. As you know, it is our understanding that courts in many countries have tackled similar issues of repair problem. Repair and exhaustion is, so your answer to this question will greatly help us understand the doctrines regarding processing and exhaustion in each country. Yeah, the first slide. Are there any court cases in your country where the court found that a consumer who purchased the product distributed in the market infringed the patent right by processing the patented product? It's a very interesting question, and it's Korea and Japan. Usually, patent right only affects the implementation of a patented invention as a business. So in many cases, processing by consumers is unlikely to be a business practice. So I want to ask to the United States and China and Germany on these issues. What is your thought on this issue, the Attorney Fang?
According to the Article 69, first paragraph of Chinese patent law, after a patented product is sold, the right holder no longer has control over the uses, sales, offers to sale, or import of the patented product. China does not have laws on whether the reconstruction, modification, or repair of a patented product constitutes infringement. Although there are relevant cases in legal practice, but as you know, as case law does not exist in China, such cases can only be used as a point of reference and are not binding in similar cases. Let me introduce some cases. First, regarding the reconstruction of patented products, there is a notable prior case widely cited in China, where the defendant purchased empty liquor bottles which were covered by the plaintiff's design, then filled those bottles with liquor for a resale. In this case, Sichuan High People's Court, in the final instance, held that defendant recycled bottles in which plaintiff owned a design patent. The defendant then filled those bottles with the liquor produced by itself for selling. Such an act goes beyond the limit of the using acts of purchase of patented products and can be deemed as a special form of manufacturing. The manufacturing of the patented products, so the acts of defendant are not in conformity with the circumstance of non-infringement provided by the patent law. So it can be concluded that after service life of a patented product ends, the act of recovering its uses is manufacturing in disguise and does not conform the conditions for patent exhaustion. And the second case relating to the modification, in respect of whether modification constitutes infringement, we have a case which is the first case relating to the modification of patented products in China. The infringer modified the products when they were still serviceable, and the technical features of the modified products were still within the scope of the subject patent claims. Therefore, the court held that the infringer's act of modifying the products was a kind of reconstruction and constituted and belongs to patent infringement. However, the court did not elaborate on the exhaustion doubt in this case. And the third last case is regarding whether the repair of patented product is relevant to the exhaustion doctrine. There is no prior cases in China. The main opinion is that where a purchase of a patented product takes necessary measures to restore the normal service condition of the product, that maintains to restore the normal service life of the product, such as act as one of the legal rights enjoyed by the user of the patented product for all purposes and should not be deemed infringement. I also agree with this opinion. Thank you.
Yes, thank you very much. So, and the Judge SCHÖN, so your answer includes some case numbers. What it means? Judge SCHÖN?
So,
the case numbers.
Thank you very much. I put some case numbers from the Supreme Court, which shows a line between repair and new production. But in order to answer your question, if a consumer is changing a product, this would not be a patent infringement because Section 11 of the German Patent Act excludes any actions that a consumer doing for private purposes. So if it's not a commercial offer, it cannot be a patent infringement. So in this question, if a consumer refills by himself, it would not be a patent infringement.
Thank you. And then lastly, the Judge ALSUP, as far as I know, the United States, the people are generous for used goods. Is it right? But what is the American position about that problem?
The United States view distinguishes between repair and restoration, or reconstruction, I should say. Repair is permissible, and reconstruction is not. So if someone buys a product and like film, a camera with film already in it, and then the film runs out, and then they replace the film, then that's okay. That's regarded as repair because consumers have a expectation that they can extend the useful life of a product that they purchase. So the exhaustion rule would say repair is okay. It is not infringement. But if you reconstruct the camera or reconstruct the product from scratch or substantially from scratch, that will constitute infringement because that would be use of the patented article. So there are a lot of cases on this, so there are lots of decisions even before the Supreme Court's decision in the Lexmark case. So that's the rule in the USA.
Yeah, thank you. Yeah, it's the, I think also this problem contains a very cultural and traditional aspects, I think. So, as such the aspects, how do the courts in your country distinguish between processing that infringes the patent rights and those that do not infringe? So what do you think about that, the issue, the Judge TSURUOKA?
Thank you. Whether the processing of a patented product or the replacement of a part constitutes a patent infringement or not is determined by whether or not it is recognized that a new patented product lacking the same identity as the original product has been manufactured. Whether a new product is manufactured or not is determined based on comprehensive consideration of the attributes of the patented product, the contents of the patented invention, the modes of the processing and parts replacement, as well as the actual circumstances of the transaction. This is the Supreme Court decision of Untitled Case. Thank you.
Thank you. And what do you think about Judge Jeong?
Thank you for the question. There is no explicit Supreme Court decision on this issue in Korea. but there are some relevant cases. The leading case of the trademark right is the Supreme Court decision, the case number 2002-3445. The Supreme Court held that an accused infringer infringed a trademark owner's right by collecting empty containers from the disposable cameras and refilling them with new films and selling them in a slightly modified packaging. And recently, we have the patent court case relating the admissible repair of the product of process invention. This decision was supported by the Supreme Court later, but unfortunately, the Supreme Court did not present any specific grounds on this issue. Anyway, in this patent court case, the court held that if an assignee legally got a product of process invention and he or she repairs or replaces consumables or parts to the extent such repair or replacement undermines the identity of an original product, it is substantially equivalent to reconstructing a new product and should be deemed as a patent infringement. However, as long as such repair or replacement of consumables or parts are related to a just part of the product, and the consumables or parts themselves are not subject of another patent right, such repair or replacement falls within the scope of the admissible repair, which is allowed as the legal right of using the product by the assignee. The issue on whether repair or replacement went to the level of undermining the identity of an original product, thereby constituting a patent infringement, should be determined based on multiple factors such as the objective properties of the product and the forms of use and the legislative intent of the Patent Act. To add my personal opinion, the above-mentioned factors as well as the content of the patent invention, difficulties of performing a repair or replacement, trade practice in each field, function of the patent, the patent system in this society, should be considered whether processing is an actual new manufacturing, thereby constituting a new patent infringement. By doing so, we can examine whether there is a sufficient reason for a patent exhaustion to be justified in a particular case. Thank you.
Yes, thank you. Thank you for your detailed answer. And this slide is the summary of each country's answer. And the next slide, it means the hypothetical case. And let's talk about this topic with a concrete case. It's a hypothetical case. With regard to the patent for product invention of disposable camera with a special anti-shake solution. If the disposable camera is distributed in the market, would the court in your country find the patent infringement for the following? First, replacing and reselling. When the original film is used up and the camera was refilled with another company's film and then resold. Second, a series of the following acts and resale. When the original film is used up and replaced with another company's film, where the replacement involved a series of steps from disassembling, replacing the film, resetting the counter, and reassembling, and then the camera was resold. Lastly, a series of the following acts and resale. When the original film roll is used up and replaced with another company's film, where the replacement involved a step of circumventing of the part that the patent holder applied to prevent film replacement, and then the camera was also resold. It's the very famous real trademark case in some countries. What do you think about this case? in Japan, Toshihiko.
Thank you. My opinion seems to be most pro-patent. Patent infringement is determined by whether the infringer is found to have manufactured a new patented product. This is the in-tank decision. From this point of view, the case 1 cannot be said to have manufactured a new patented product and would not constitute a patent infringement. On the other hand, the case of 3 is considered to be patent infringement because it can be said that a new patented product has been manufactured. 2 is a delicate case. I tend to think that is a patent infringement, but there can be both conclusions. Thank you.
Thank you. Thank you. Your concrete opinion. And what do you think about this topic, the Judge Jeong?
Regarding the first question about this hypothetical case, I think that refilling the disposable cameras with new films, this basically belongs to the category of admissible repair. Because the film itself does not have any direct relationship with the unique solution, that is the part for blocking the tremor of the lens focus as presented in this hypothetical case. However, regarding the second question about this hypothetical case, if the whole process of replacement will get to the level which is equivalent to the new manufacturing of the patented product in terms of the degree of the difficulties of repair or replacement, it may be recognized as a patent infringement. So the actual conclusion will vary from case to case. Regarding the third question about the hypothetical case, I think that it is possible that if the specific technical measure means taken by the patentee reflect on the objective properties of the product, the act of disabling means so as to resell the patented product seems to be considered in deciding whether the patent is exhausted or not. Basically, I think that if there is a big change of the objective properties of the product, it is deemed as a new manufacturing. Of course, although the overall comprehensive review of the specific circumstances of the case should be accompanied. On the other hand, the general life cycle of the product of the same kind as the patented product can be taken into account when deciding whether the patent is exhausted or not in view of appropriate protection of patent. Thank you.
Thank you. Thank you, your detailed answer. And what do you think about this topic, Attorney Jeong? You have a different opinion?
Thank you. In my view is that for all of the 3 cases, the patent would be exhausted for the following reasons. The first, the patent is directed to a anti-shake solution, not a film. And the second, if the patented components of an article are still in a usable condition, a mere replacement of unpatented components, such as a film in this case, can consider to be permissible repair. In comparison, the Korean Supreme Court in Trademark Case I mentioned earlier stated that the lifespan of a disposable camera ends once the original film is used up, and the replacement of film would constitute a prohibited reconstruction. So I want to say that this question needs a case-by-case analysis, and if the patent is directed to a film, I think that replacing a film can constitute an infringement of the patent. So I believe we should carefully review the specific claim language and the product. And regarding the question 3, my view remains the same. For your reference, in the United States Lexmark case, the device has a special chip that prevents refurbishing. But the defendants disabled the chip and refurbished the cartridges, but the United States Supreme Court still recognized the patent exhaustion. So I think that rationale can apply to this case. So my view is that patent would be exhausted. Thank you.
Yeah. Yes, thank you. And this topic looks simple, but not easy case. What do you think about the Judge ALSUP?
I agree with the last two comments, at least 95%. And I think, in short, all three of these examples would be found to be exhausted under the U.S. law and would be deemed to be repairs. So I think the patent holder would lose in all three instances.
Yeah, very interesting opinion. Thank you. Yes, I will wrap up this topic and move on the next topic. Next topic is another interesting topic, and the process invention and exhaustion. Unlike product inventions, there have been disagreements over whether exhaustion can be recognized for process inventions because of the uncertainty regarding which aspects of such inventions are transferred by the first sale. Korean scholars have been divided over the issue as well. And Korean courts have recognized the exhaustion of a product invention so far, but lower courts have been divided over exhaustion of a process invention until the Supreme Court of Korea recognized the exhaustion of a process invention under certain conditions in a decision rendered on January this year. So, does your country recognize the exhaustion of a process invention? If not, what is the rationale for not recognizing exhaustion? I would ask this question to Judge Jiyoung. What do you think about this topic?
Thank you. The in-tank Supreme Court decision does not comment on whether the process invention will be exhausted or not. However, the IP High Court decision in the same case held that the process invention would be exhausted in the following two cases. The first is that a case that a patent right is granted not only to the process invention, but also the product invention, and that the technical idea of these inventions are not different. In such a case, if the patented products are transferred, the process patent also will be exhausted. And the second case is when the patentee or licensee transfer a device that is used only for the implementation of the patented process, or a device that is used for the implementation of the patented process and is indispensable for solving the problems of the invention. In such a case, the process patent will also be exhausted. Thank you.
Thank you. Thank you, your opinion. And what do you think about this topic, the attorney, Fang, in China?
Yes. In China, the Chinese patent law does not expressly provide any provisions for the exhaustion of process invention. Under the current Chinese law framework, the exhaustion of process patents can only be applied to the circumstance where the products are directly obtained under the patented process. In a very famous case, a Chinese company called Xidian Jietong and the Sony China case, the Beijing High People's Court points out during the second instance that according to the exhaustion doctrine provided Article 69, first paragraph of the Chinese patent law, only patent rights in products which have been legally sold can be exhausted, and it cannot be held that a legally sold special purpose device, element, or component which has implemented a patented process or is used for manufacturing a patented product will lead to the exhaustion of process or product patent. So only patent rights regarding to a patented product or a product directly obtained under the patented process can be exhausted. Purely used process patents do not involve any products and so has no exhaustion issues. Thank you.
Yes, thank you. And the United States has the famous case about this topic. What is your opinion about this topic, Judge ALSUP?
The United States Supreme Court in 2008 held that the patent exhaustion rule does apply to process patents or method patents, though in my own view it's going to turn on individual facts and is more complicated perhaps. The essence of the Supreme Court's rule was that the authorized sale of an article that substantially embodies a method patent exhausts the patentee's rights. So the answer is yes, it does apply. The rule does apply to method patents.
Yes, thank you. And Judge Lee, will you give your opinion after we listen many countries' opinion? Give us your opinion, please.
Actually, before January 2019, the lower court's decisions have been divided, but according to the Supreme Court decisions, the process invention can be subject to exhaustion under certain conditions, so-called substantially embodiment, which is similar to Quanta case in the United States. In other words, if the patentee lawfully assigned the product which is substantially embodied process inventions, the patent will not have its effect on the assignees. Supreme Court stated several reasons for exhaustion in process inventions. I think this is very important thing. They suggest three reasons. The first, if a process invention is excluded from exhaustion, the patentee will be able to easily avoid the patent exhaustion by inserting process inventions into the claims. It is very not fair. So, the second, the patentee also has opportunity to acquire profit throughout practicing patent or process inventions. And finally, if the assignee should get permission from the patentee, whenever a process invention is practiced by using the product, it may undermine freedom of distribution and safety of transaction. I think the reason is also similar to Quanta cases. I think that is a globalized picture of IP cases, I think so. And also, Supreme Court suggested three related factors in order to determine whether the product substantially employs process inventions. The Supreme Court suggests three factors. So, is it possible to suggest three factors in this presentation? How about the time? Judge Lee, is it possible to present this?
Please, briefly.
Okay. Yeah. The first factor is that whether the only generated accepted intention of product is executing the process invention or not. The second factor is that whether the product contains all of the elements to comprise the essence of technical idea on the process invention. The third factor looks at the proportion of process that is carried out using the product and compares to out of the overall process of inventions. So we have to focus on these three factors in any trial about process inventions. I think so. Yeah, that's it.
Thank you. Thank you very much. Yeah, Yeah, we discussed the process invention, and we discussed many interesting aspects. So next topic is the parallel import and exhaustion problem. As you know, the parallel import is the traditional issue of IP area. And as you know, the term parallel import of a patent product means importing a product that patented overseas, which has been lawfully sold by the overseas patent holder into the country without permission from the holder of the domestic patent. As you know, in this problem, the patent and the trademark, including copyright, are treated a little bit differently, I think. So I will ask this issue of patent and trademark separately. First, in your country, are the patent holders allowed to stop parallel importing of patented products by exercising their patent rights? I would ask this question to all the speakers from the jurisdiction. Could you give me your opinion? Give us.
In Germany, a patent holder can use the patent to stop parallel import if the original product is not distributed within the European free trade area. More interesting part might be the burden of proof. This applies for trademark cases and patent cases as well, because exhaustion of right is a defense. So according to our understanding, the defendant who uses the defense has a burden of proof, but this would mean that the defendant has to tell where he received the parallel imported goods from. And so in this case, he may win one case, but for the future, the right holder might be able to stop the distribution channel where the goods come from. So especially for trademark law, we do have sometimes a switch of the burden of proof, but this is a complicated issue I don't want to mention, but you have to take focus on it.
Yes, thank you. Thank you for your answer. And what do you think about this topic, Judge ALSUP?
Thank you. The Supreme Court answered that question in the Lexmark case and said that sales abroad of patented goods, then they get brought back into the United States by importing. The patent exhaustion rule still applies, and you cannot stop the import of the patented good even though the original sale was made overseas.
Thank you. It's a Lexmark case, though.
Correct.
And what is your opinion in China, Attorney Fang?
In China, comparing with the previous Chinese patent law, the Third Amendment in 2008 adds the act of importing. That is, the acts of importing any patented product or product directly obtained under the patented process after the product is sold by the patentee or as licensed entity or individual should not be deemed as an infringement of the patent. The Chinese patent law has established the doctrine of patent exhaustion in parallel importing through the Third Amendment. In other words, China recognized the doctrine of international patent exhaustion. Thank you.
Yeah, thank you. China has written the provisions. It's another good solution, I think. What do you think about this topic, Judge TSURUOKA?
In Japan, the BBS Supreme Court decision in 1997 held as follows. When the patentee legally assigns the patented product in the foreign countries, the use of the patent rights by the patentee in Japan is restricted if the following conditions are met. One, if the direct assignee is the other party, the patentee cannot exercise the patent right unless there is a special agreement in the assignment agreement to exclude Japan from the sales destination or area of use of the patented product. 2, if the person who has received the transfer of the patented product from the assignee is the other party, the patentee cannot exercise the patent right unless the above agreement exists and is clearly indicated on the patented product. And the basis for such restrictions is not exhaustion, but the patentee's implied consent. Thank you.
Thank you. Thank you for your explanation about the famous case, the BBS case. Yeah. Lastly, the attorney Jeong, what do you think about?
Yes, in my opinion, the patentee can't stop parallel importation due to international patent exhaustion. And in related court decisions, the Korean Supreme Court allowed parallel importation in trade case, but the court didn't mention the exhaustion theory as a basis in that case. And there is an old lower court's decision issued in 1981 that recognized international patent exhaustion and allowed parallel importation. Yes, thank you.
Thank you. And the next question is, as I said to you, the trademark and copyright problems. Are trademark, including copyright holders, allowed to stop parallel import of a product exploiting trademark, etc., by exercising their trademark rights? I would ask to what do you think about this topic, the Judge SCHÖN?
Same rules apply as for patent law, so they can stop.
The same. Yeah, the same principle. What is your Judge Judge Jeong?
Thank you. In the Supreme Court decision, case number 99.42322, the Supreme Court held that as parallel import per se is a lawful act and does not constitute trademark infringement. A parallel importer is authorized by law to sell the product displaying the registered trademark. Meanwhile, in another Supreme Court decision, case number 2006.40423, relating the parallel import in the trademark case, the Supreme Court presents 3 conditions to be qualified as a legal parallel import. First, foreign trademark owner or rightful licensee should attach the trademark on the import product. Second, the trademark attached on the import product should be deemed as marking the same source with the registered trademark in Korea through the legally or economically close relationship between the foreign trademark owner and the registered trademark holder in Korea, or any other reason. Third, there should be no substantial difference in quality between the import product and the product with the registered trademark in Korea. And difference in quality here refers to performance and durability of the product itself, not referring to provision of the supplementary service, such as any customer support or free repair or component replacement. Thus, in Korea, it is difficult to stop parallel import of authentic goods that satisfy these 3 conditions in the above-mentioned Supreme Court decision. Thank you.
Yes, thank you. Thank you very much. Would you give your opinion, Judge TSURUOKA?
Thank you. Japanese position is very similar to the Korean position. According to the February Supreme Court decision in 2003, the trademark owner cannot prevent parallel import if the following 3 conditions are met. 1, a trademark is legally attached in foreign countries by the trademark owner. 2, foreign trademark owner and Japanese trademark owner is the same or economically the same. So the trademark shows the same source as the trademark owner in Japan. 3, the trademark owner in Japan can control the quality of the imported product directly or indirectly. For this reason, there is no difference in the quality guaranteed by the trademark right between the imported goods and the goods to which trademark owner have attached the registered trademark in Japan. And the ground for such restriction is that parallel imports lack substantial illegality. Thank you.
Thank you. Yes. Next, what is your opinion, Attorney Fang?
Thank you. In China, there are no explicit provisions regarding the parallel import in the trademark law. However, in judicial practice, parallel import of trademark billing goods has the following features. First, the trademark rights involving parallel imports of goods are protected by the laws of the importing countries. Second, the goods imported by the parallel importers are goods of the same brand manufactured or sold by the trademark holders or trademark use right holders. Third, parallel importers obtain the goods through the legitimate means. Fourth, trademark importers distribute or resell the goods of the trademark holders or trademark use right holders in the importing countries. So in certain circumstances, parallel importing may constitute trademark infringement. It is not deemed as trademark infringement if the goods are imported to China through the normal custom clearance and sold in accordance with mandatory laws or administrative regulations of the China. However, it may be deemed as infringement if the goods are not cleared from the customs and the identification function of the trademarks are damaged, or the sale of the goods violates the mandatory law or the administrative regulations of the China. Thank you.
Thank you. And lastly, there are some cases in the United States. Would you explain the cases, Judge ALSUP?
This problem is not really an exhaustion problem, but it's a trademark infringement problem. And I'll give you just two examples so you can see. Just take the obvious case of counterfeit goods that come in as imports. Well, every judge in the USA, once you learn they're going to be counterfeit goods, would enjoin that importation and sale of the counterfeit goods because of the fact of confusion of consumers. So that has nothing to do with exhaustion. That's going to stop the importation of counterfeit goods at the threshold. Now, the second example is not quite as clear because it's not counterfeit goods, but let's say that the owner of the trademark has licensed somebody in Spain, that's an actual case, to manufacture, in that case, U.S. Cabbage Patch dolls, but to sell them only in Spain, and they wind up getting sent into the United States, imported into the United States. Well, that was enjoined because the prescription for manufacture in Spain was different from how it would be manufactured in the USA, and further, the court found that that difference would be material to the consumer in the USA. So even though those weren't counterfeit goods, they were, the importation of those goods was enjoined by the U.S. District Court. So it's not an exhaustion problem. It's just analyzed on the same rules we heard about earlier today on trademark infringement. That's That's the situation in the USA.
Thank you. Thank you very much. And the next slide and the next is just a summary of each country's explanation. And last slide is the answers of this question. Other than IP laws, does your country have any other regulatory or supervisory statute, including international treaties, providing for permissibility and the requirements of parallel import of patented products or products exploiting trademark, etc. And each country, the answer like that. For example, Korea, the Tariff Act is the one answer. So we ran out of all slides. Do you have any comments on today's discussions, panels? Yeah, so from now on, we are running out of time, so we will only one questions from the audience. If someone who want to ask something.
Somebody.
Yeah. Bring the microphone.
Yeah, thank you for your very informative presentations. I have very short knowledge on the field of exhaustion, but one question comes to my mind. Recently, the direct purchase from abroad is very popular among Korean customers. I wonder whether the same principles of exhaustion can be applied to the direct purchase from the abroad.
You wanted to, who should answer this question?
Any panel.
Panels? What about ALSUP?
I'm going to pass.
I'm going to pass? Use the pass card. And that question is very important and basic question, I think, but the answer is not so easy, I think. So, and at the time limit, so I think so we discussed because the question is bigger than I expected. Sorry, that. Thank you very much. This concludes session 3. Thank you to all our speakers. Although the situations are different for each of our speakers, but their prestigious opinions are very helpful to us and are the keys to understand each other. And also, I would like to thank you, all audience, for listening carefully. Thank you very much. Thank you very much.
That was a very fruitful session. You must be exhausted through learning exhaustion. Thank you all for the great session, and also thank audience for your attention. This ends today's program. We are going to carry on with this productive discussion tomorrow. I hope you enjoy a pleasant evening and look forward to seeing you again tomorrow. Thank you. One more thing. Make sure you take a beautiful flag with you. It's a limited edition. You cannot get it again. Thank you.